So now we've come to the fourth chapter of Indian polity, which is the salient features of the Constitution. Indian Constitution is unique in its contents and spirits, though borrowed from almost every constitution of the world. So India's constitution is inspired from some of the greatest constitution of the world. So it would be mentioned in the following lesson, but for now let's just know that the constitution of India is borrowed from most of, like, it's almost all of the content of the Constitution of India is borrowed. And next comes the Kesava Nanda Bharati case, which is 1973. The Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the of basic structure of the Constitution. So the Parliament does not have the power to alter the basic structure of Constitution. So they can alter some parts of Constitution, but not the basic part of the Constitution. So that's what the Article 368 means. So I would like to point out that it would be very good for you if you remember this Article 368. And then comes the salient features. Constitution of India is the lengthiest part of all the written constitutions of the world, which means India's constitution is comprehensive, it is elaborate, and it is a detailed document. So actually the Constitution of India is the lengthiest of all the written constitutions of the world. It consists of the preamble. So we have the preamble. We have about 470 articles, and articles are divided into 25 parts. And then we have 12 schedules. So 12 schedules are like, it's very important to know the 12 schedules of the Indian Constitution. No other constitution in the world has so many articles and schedules. So how much article does our Indian Constitution have? It is 470 articles, and we have 12 schedules. So it's very much for a constitution, and no other constitution in the world has this much of the article and schedules that we have in India. Until 2019, the erstwhile state of Jammu and Kashmir has its own constitution and thus enjoyed a special status by virtue of Article 370 of the Constitution of India. But in 2019, this special status was abolished. So which article gave the special status of Jammu and Kashmir? It was Article 370 that gave Jammu and Kashmir the special status, but it's abolished in 2019. Further, the Jammu and Kashmir Reorganization Act of 2019 separated or bifurcated the state of Jammu and Kashmir into two separate union territories, namely the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. So, Jammu and Kashmir used to be a state, but it has been separated into two union territories, which is the Union Territory of Jammu Kashmir and the Union Territory of Ladakh, by which law? By the Jammu and Kashmir Reorganization Act of 2019. The structural part of the Constitution is to a large extent derived from the Government of India Act of 1935. So, most of the part of the Constitution of India is derived from the Government of India Act of 1935. So, if you want to know more about the Government of India Act of 1935, you have to go to the first chapter of Indian polity, which I have uploaded in my channel, which is a historical background. So you will find the everything that's included in the Government of India Act of 1935. So this Government of India Act of 1935 is has a very important role in the constitution making. So I think it would be better if you have great knowledge about this one. 1935, like, to be precise, you need to know more about this. And like, if you know this, then you would have the, the major idea about the constitution. So please try to and check it out, the video that I have made of it. Then coming to the lesson, the philosophical part of the Constitution, the fundamental rights and directive principles of state policy, which is also shortened as DPSP, derives its inspiration from the American and Irish Constitution. So fundamental rights, the right to this, the right to that, these all, and the DPSP has been derived, it's inspired from the American and the Irish Constitution. And a political part of the Constitution, like the principle of cabinet government, relation between the executive and the legislature, this have been largely drawn from the British Constitution. So this is how, like we're showing here some inspirations of the, the places where the Constitution has been inspired from. Then comes the other provisions of the Constitution has been drawn from the constitutions of Canada, Australia, Germany, USSR, which is now called Russia, France, South Africa, Japan, and so on. So, like, the Constitution of India has been derived from some of these countries that we've mentioned here. And India's federal features include, like, two governments, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, and bicameralism. So these are the features that make India seem like a federal. So how? Like federal, we say in the previous chapter, we say that federal is a kind of governance where the power has been separated between the country, and the regional governments have been separated. So like that, how does India how can India be called a federal? So because we have two governments. Yes, we have two governments, state government, central government, and then there's also division of powers, and then we have a written constitution, and then the constitution is the supremacy, and our constitution is also rigid. And yeah, we can call it like it's neither rigid nor flexible, but sometimes that it has also it's also in some point of time it is rigid. Sometime we cannot say that it's flexible or something like that, but sometimes it is also rigid. So when the constitution is rigid, we kind of make it into the federal. So it's rigid. Then we have an independent judiciary, and we also have the bicameralism. So bicameralism, as we have known from the first chapter, like it's the separation, like the Rajya Sabha and Lok Sabha. This separation is called bicameralism. And then we have, let's see on the non-federal or the unitary features that India have. We have a strong center. Yes, center looks after all of the states. Yes, it has. We also have a single constitution. Yes, we also have a single citizenship, and there's also flexibility of constitution. But we also say there is a rigidity of constitution, but still we also have at some point of time, at some part, the constitution sometimes become flexible, that it can be amended in according to the ordinary laws. And we also have integrated judiciary, and then we have the appointment of state governments by the center. We also have the All India services. We also have emergency provisions and so on. So however, Article 1 describes India as a union of states, which implies two things: that India federation is not the result of an agreement by the states, and two, no state has a right to secede from the federation. So by secede we mean you know by secede we mean that breaking away, or like withdrawing. Like, in no state has a right to withdraw from India. And India is also made up of states, but these states does not become part of India by agreement. So that is why we say India is the union of states. It's we voluntarily agree, we voluntarily join in the union of India, but not by agreement. Or we don't, and also no state has the right to withdraw from India's federation, from the union of the state. And then there is parliamentary form of government. The parliamentary system of British is opted rather than the American presidential system of government. Parliament system is based on the principle of cooperation and coordination between legislative and executive organs, while the presidential system is based on the doctrine of separations of power between the two organs. So India, by India kind of incline more towards the parliamentary form of government rather than the Americans presidential system of government, because when it comes to parliament system, all the legislative and the executive works under the cooperation and coordination between them. And for the presidential system, they just they have separate powers and they don't just cooperate with each other. So that is the reason I think that India constitution works as a parliamentary form of government. The doctrine of sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. The Supreme Court, on the other hand, can declare the parliamentary law as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major part of the Constitution through its constituent power. So the doctrine of sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. So, like from for India, the Supreme Court also has the power to declare that the parliamentary laws are unconstitutional. But at the same time, Parliament can also amend the major part of Constitution through its constituent power. So that's how the um, judicial supremacy works sometimes. And the Indian constitution establishes a judicial system that is integrated as well as independent. So Supreme Court stands at the top, High Court is state level, district courts and other at the lower courts. So Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the constitution. So Supreme Court, as we all know, Supreme Court is the top court of India. And you must also remember that the judicial system of India is integrated, but it is also independent. And when it comes to the Supreme Court is a federal court. Here it's the highest court of appeal. You can appeal here, and the judgment that they make is the highest, the most important one. And they are also the guarantor of the fundamental rights of the citizen. So if any of your fundamental rights are violated, then Supreme Court guarantee that they can restore the fundamental rights that have been violated, and they can give punishment to the people who violated it. And they're also the guardian of the constitution. So constitution needs to be guarded by something. Now Supreme Court is the guardian of the constitution. And then now comes the fundamental rights. So fundamental rights is included in the part 3 of the constitution, and article of the India is separated into 25 parts. So fundamental rights is one of the part 3 of the constitution. So we have right to equality, and then we have right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So we have 6 fundamental rights, and it's very much important that you remember all of these. Now, Article 31, this is very important. This is very much important. You must keep it in your mind, because Article 31, which is the right to property, it was one of the fundamental right, but it was deleted from the list of fundamental rights by 44th Amendment Act of 1978. So it's deleted, and it is made a legal right, not a fundamental right, but a legal right under Article number 300A in the Part 12 of the Constitution. From being in the Part 3, it has been moved to Part 12 of the Constitution under Article 300A, which used to be Article 31. So remember this, Article 31 is deleted and it's called right to property, but it has been listed under the legal rights of Article 300A in the Part 12 of the Constitution. However, the fundamental rights are not absolute and subject to reasonable restrictions. They can also be suspended during the operation of a national emergency, except the rights guaranteed by Article 20 and 21. So, the fundamental rights, these are not absolute at all, because at some point of time when there is an emergency, national emergency in the country, these fundamental rights that we've mentioned before here, right to equality, right to freedom, right against exploitation, everything that's been included here, they can be, suspended. But Article number 20 and 21 except these two articles. So Article 20 and 21 is included in the right to freedom. So only these articles are given the exceptions. Then DPSP. So the directive principles are meant for promoting the ideal of social and economic democracy. So DPSP is to promote, the ideal of social and economic democracy. They seek to establish a welfare state in India. So DPSP is related with the welfare thing. So always remember, DPSP means welfare. And they are non-justiciable in nature. That is, they are not enforceable by the court for their violation. So non-justiciable means that, like for fundamental rights, if they're violated, then we can move to the Supreme Court and we can obtain our rights that had been violated. But when it comes to DPSP, it is to promote, social and economic democracy, to establish a welfare state of India. But still, if they are violated, if some of the rights that were given are violated, and it is under DPSP, then we cannot move to the court. The court cannot just give us justice for that, because the DPSP is non-justiciable in nature. But the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. But the Constitution says that even if they are, if even if they are not the like they are even if they are non-justiciable, but we should not take it for granted. It should be the fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So that is what DPSP is. And in the Minerva Mills case, 1980, the Supreme Court held that the Indian Constitution is founded on the balance between fundamental rights and directive principles. So the Indian Constitution is founded in the balance between fundamental rights and the directive principles. So both are very important. Now comes the fundamental duty. So where was the fundamental rights derived from? So it is derived from the American Constitution. Then comes the fundamental duties. It's the Part 4A of the Constitution specifies the 11 fundamental duties, which is to respect the Constitution, national flag, national anthem, to protect the sovereignty, unity, and integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture, and so on. Like DPSP, the fundamental duties are also non-justiciable in nature. So, non-justiciable means courts won't issue orders or provide remedies for violation of the non-justiciable rights or issues. So, remember the meaning of non-justiciable is the court won't issue orders or provide remedies for violations of non-justiciable rights or issues. And then comes the secular state. Now, on the 11th point, it comes the secular state. It does not uphold any particular religion as the official religion of the Indian state. So, being secular means there is no official religion of India, and the term secular was added to preamble of Indian Constitution by the 42nd Constitutional Amendment Act of 1976. So, when you are exposed to any word called secular, then that should mean that there's no official language of the country, of the particular country, or but for this topic, there's no official religion of India, and that is why we call India as a secular state. And then comes the universal adult franchise. So the Indian Constitution adopts a universal adult franchise as the basis of elections to the Lok Sabha and the state legislative assemblies. Not less than 18 years of age has the right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, and so on. So there's no discrimination based on that, but they should be not less than 18 years. And then that is single citizenship. So for India, there should be only a single citizenship, which is the Indian citizenship, and they cannot have two citizenship for India. And then come the independent bodies. Indian Constitution not only provides for the legislative, executive, and judicial organs of the government, which is central and state, but also establishes certain independent bodies like Election Commission, Controller, and Auditor General, UPSC, State Public Service Commission, etc. These are like Indian Constitution does not confine the opportunity, does not confine everything to the central and state government, but also they establishes these certain independent bodies. And then next comes the emergency provisions, like the national emergency, the state emergency, and the financial emergency. So when we call a national emergency, it's on the ground of war or external aggression or armed rebellion. So it's the Article 352. Remember that national emergency is on the ground of war or external aggression or armed rebellion. And the state emergency means the president's rule. So currently in 2025, Manipur is under the president's rule because it's on the ground of the state emergency is imposed on the ground of failure of constitutional machinery in the states under Article 356, or the failure to comply with direction of the center, which is Article 365. So just remember that there's some interchange between 356 and 365. So 356 would be failure of constitutional machinery in the states, and 365 would be failure to comply with the directions of the center. And then next is the financial emergency. It is a threat to financial stability or credit of India, which is Article 365. And then comes the three-tier government. The financial emergency should be under, it's not under Article 365, but it is under Article 360, because Article 365 is the state emergency and Article 360 should be the financial emergency. And then comes the three-tier government: state, central, and local governments. So in local governments we have panchayats. In panchayats is for the rural and municipalities is for the urban. And then comes the schedules of the constitution. Like we have mentioned earlier, that the constitution of India has 12 schedules. So here are the 12 schedules that we would be learning here. So the 12 schedules of India. For first schedule, it means the names of the states, union territories, and their territorial jurisdiction. And the second schedule is the provisions relating to allowances, payments. So second schedule is related with the payments, mostly the salary. Let's say for the first schedule is for the name of the states and union territories and everything, like everything related with territory. And the third schedule is the oaths or affirmations. And the fourth schedule is the allocation of seats in Rajya Sabha and in the states and the union territories. And the fifth schedule is something related to administration and control of the scheduled areas and scheduled tribes. So this will be, you will learn about this more detailed on the coming chapters. So just brace for it. So for the sixth schedule, the provisions relating to administration of tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. So these provisions relating to this, so always remember that in the states of Assam, Meghalaya, Tripura, and Mizoram, in these tribal areas, the sixth schedule is relating to the provisions of the administration of these tribal areas. And then comes the seventh schedule, which is the division of powers between the union and the states in terms of union list, state list, and concurrent list. So that is a division of the union and the states. So eight schedules is related with the languages and its recognition by the constitution. So presently in India, there are 22 languages. Like as the name mentioned, you need to know the names. Assamese, Bengali, Boro, Dogri. These are in alphabetical order, not in the timeline. Gujarati, Hindi, Kannada, Kashmiri, Konkani, Maithili, Malayalam, Manipuri, Marathi, Nepali, Oriya, Punjabi, Sanskrit, Santali, Sindhi, Tamil, Telugu, and Urdu. So these are the 22 languages that had been recognized by the constitution. And then comes the ninth schedule. So for the ninth schedule, it's the acts and regulation of the state legislature dealing with land reforms. So ninth schedule is always related with the land reforms and the abolition of zamindari system and of the parliament dealing with other matters. And then comes the 10th schedule. 10th schedule is the disqualification on the ground of defection. And then comes the defection. It's not just only for the parliament but also for the state legislature. So 10th schedule has provisions relating with the parliament and the state legislatures on the ground of defection. And then for the 11th schedules, it's the powers and authority and responsibility of panchayats. And 12th schedule is the power, authority, and responsibilities of the municipalities. And then comes the parts of the constitution. Like I have mentioned that there are there are 22 parts here. So let me add it for you. Part 1, union and its territory. Part 2, it's a citizenship. And part 3, it's a fundamental rights. And then to mention you, there are 22 parts here. So these 22 parts are how the constitution started. These 22 parts were from the older version, but under the new amendments, under the new amendments, there are 25 parts and some added articles. Because first of all, we have learned that there were 22 parts. We used to have 395 articles, but now we have 448 articles, 12 schedules, and 25 parts. So remember that. I'll just write it for you. Originally, India used to have 22 parts and 395 articles and 8 schedules. But currently we have 25 parts, 448 articles, and 12 schedules. So never forget this. Now, part 1, Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principles of state policy or DPSP. Part 5, Union government, executive, parliament, legislative powers of president, the Union judiciary, controller, auditor general of India. In Part 6, the state governments, which is general, the executive, the state legislatures, legislative powers of governor, their high courts and subordinate courts. And Part 8, which is the Union territories. Part 9 is the panchayats. And under panchayats, we also have the municipalities, the cooperative societies, and the part 10 we have the scheduled and tribal areas. So this part we are going to be learning this in detail in the coming chapters, so no need to worry about it. The articles and all, it would be coming under these under these parts. And the part 10, the scheduled and tribal areas. Part 11, relations between the union and the states, which is legislative relations and administrative. And part 12, which is the finance, property, contracts, and suites. And then comes part 13, which is trade, commerce, and intercourse between the territory of India. And part 14, services under the union and the states. And under 14a, there's also called tribunals. Part 15, there are elections. Part 16, special provisions relating to certain classes. Part 17, official languages. Part 18, emergency provisions. Part 19, miscellaneous. Part 20, amendment of the Constitution. And Part 21, temporary, transitional, and special provisions. And Part 22, short title, commencements and authoritative texts in Hindi, and repeals. And then the sources of Indian Constitution. Like now, first we're going to be learning about the Government of India Act 1935. So from this, we have taken the federal scheme, office of the governor, the judiciary, the public service commissions, the emergency provisions, the administrative details. These are being taken from the Government of India Act. And from the British government, we've learned the parliamentary government, the rule of the law, the legislative procedures, the single citizenship, the cabinet system, and the bicameralism. And then from the US Constitution, we have learned the fundamental rights, the independence of the judiciary, the judicial review, impeachment of the president, removal of Supreme Court and High Court judges, and post of the vice president. And from the Irish Constitution, we know about the DPSP, nomination of members of Rajya Sabha, and method of election of president. And from the Canadian Constitution, we know the federation of a strong centre, vesting of residuary powers in the centre, appointment of state governments by the centre, advisory jurisdiction of the Supreme Court. And from the Australian Constitution, we know about the concurrent list, the freedom of trade, commerce, and intercourse, and joint sitting of the two houses of parliament. These are all from the Australian Constitution. And from the Weimar Constitution of Germany, we've known about the emergency provisions. From the French Constitution, we've known about the republic, the ideas of liberty, equality, and fraternity in the preamble. So about the preamble, we'll be knowing in the coming chapter. So don't worry, I will give you the detail of these principles. And then in South America of African Constitution, it's a procedure for amendments of Constitution and election of members of the Rajya Sabha. And from the Japanese Constitution, we have taken the procedure established by law. And from the Russian Constitution, we have taken the fundamental duties and ideal of justice in the preamble, which is the social, economic, and political justice. And now from the Russian Constitution, we have learned and now from the Russian Constitution, we have learned about the fundamental duties and ideal of justice in the preamble, social, economic, and political. Thank you so much.